Hello! In this clip from our Justia webinar, How to Effectively Handle Long COVID Disability, Edward Dabdoob guides us through all the steps needed to prove long COVID is a disability. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
All right. What do we do about all of this, right? We spoke about the difficulty with these claims. They are inherently subjective. Treating physicians may not exactly know how to treat these conditions properly. Insurance companies, doctors certainly don't have the expertise to review these types of claims. And then the insurance company are taking advantage of the inherently subjective nature of the condition. They're using contract limitations and other exclusion provisions in the insurance contracts to not pay benefits or limit paying benefits, right? And then you get into court, you have ERISA where you're confined in what you can do from an evidentiary perspective. You're not allowed to introduce new evidence. You can't bring in witness testimony from your client's doctors, friends, and colleagues. You're very restricted, and you may be facing an uphill battle with an arbitrary and capricious standard where you have to convince the judge not only was the insurance company's decision completely wrong, but it was also completely unreasonable. Well, this is a strategy we have been using when a long COVID disability claim is denied. We follow this strategy to a T for the appeal process to the insurance company, right? One of the requirements of ERISA is that before you can file a lawsuit, you must go through this pre-lawsuit appeal process with the insurance company. And essentially, you're appealing back to the insurance company and saying, hey, please admit that you were wrong and please pay benefits or we'll have to file a lawsuit, right? And it's a bit tricky because the insurance company has to examine its own wrong behavior and correct that wrong behavior and acknowledge it was wrong and pay benefits. It's not going to, they typically don't do it on a whim. They have to be put in a position where they believe they do not have a chance of succeeding in court for them to first then say, okay, we will approve this appeal and avoid unnecessary litigation. Now, what I'll say is when we use this strategy, we don't keep metrics or internal statistics here at the firm, but the overwhelming majority of the firm's long COVID claims have gotten approved through the appeals process. I think we've had one or two that slipped into litigation and can't disclose the outcome of those litigations other than to say it was favorable for the client. And I think the insurance carrier's attorneys can recognize when you've created a file that's an absolute winner for the plaintiff, and they will adjust how they litigate that case. They would be hesitant to take that case to judgment. So let us look then at what are the things we do when we have to appeal. First, we have to build up our medical evidence, first and foremost. The majority of the long COVID claims the firm has handled, the client comes to us with somewhat weak medical evidence. There's not always a long enough history of treatment in place and not always treating with the right doctors for long COVID. And so in many ways, you almost feel like you started from scratch. We have over the last 3-4 years, we've been building up a network of doctors across the country, reaching out to some of the luminaries, the experts in the field of chronic fatigue syndrome and long COVID. And now we have a network across the country of physicians who can not only test our clients, they can perform independent medical examinations of our clients. They can write independent peer review reports that articulate exactly why or how our clients are unable to function on a reliable and consistent basis. And so we end up leveraging this network. And so let's just say we have a hypothetical client, let's just say Miss Brown. So Miss Brown comes to us. There's a dearth of medical evidence. She has long COVID. She may have been diagnosed with it, may not have been diagnosed with it. It really doesn't make a difference to us as to whether we accept that case or not, because we're not focusing on the etiology. We're not focusing on the cause. Instead, we're focusing on the symptoms and the restrictions and limitations resulting from those symptoms. And one of the first things we would do is we would gather all the medical records. And when we get all these medical records, we start already reaching out to the treating physicians to letting them know we're going to be sending Miss Brown to this sort of testing, and we will circle back to you. And the first test we send the client to is called a CPET. It's the first one on the bullet point. Cardiopulmonary exercise testing. We'll talk about it some more in case law below. But essentially, it is preferably a 2-day test that you send your client to that monitors the cardiopulmonary functioning upon exertion, physical exertion. How is the body responding to physical exertion? And without getting into the details and the science of it, it really is the best thing that we have right now. It doesn't measure fatigue per se, but it does support, I would say objectively, that if the client is suffering from debilitating fatigue, and that indeed is one of the hallmark symptoms of long COVID. And so we get this CPET report. And the CPET report ideally would say, yes, your client's unable to function on a reliable and sustained basis. Here are the reasons why. The report will also include data on how the client performed on the functional testing. Now, this is an important point because insurance carriers will challenge every report you get. So what we do is we take the CPET report and we send the report with the data to a second CPET expert who had nothing to do with the initial testing. We then ask this second expert, please take a look at this report and the data and tell us if it is accurate and reliable. And now, ideally, we get a report back from the second expert that validates the original CPET report. So now we have a CPET report and a validation of the CPET report from an independent expert. Next, most clients with long COVID also experience cognitive impairment. You cannot look at somebody and tell if they have cognitive impairments or not, unless it's extreme, right? But we're talking about your average case here. And so what we do is we send clients for a neuropsychological evaluation. Okay, that is a battery of cognitive testing. It's done by a neuropsychologist, and it is a way of, as best as you can, objectively measuring cognitive impairments. And we would get a report from our neuropsychologist that walks through the different areas of cognitive testing, shows how the client is performing in the different areas. And this is an important point. You must have your neuropsychologist include validity testing in this report. A validity testing is a way of measuring your client's efforts to weed out things like exaggerating or faking on the test. Because if you don't have validity testing, you're opening up yourself to the insurance carrier throwing out your neuropsych report on the basis that it has no validity measures built in. No, you get back a neuropsychological evaluation report. It looks lovely. It says your client can't work. It goes into all the areas where your client is performing, underperforming. And like we did with the CPET, we notate the neuropsychological evaluation, the neuropsych report, and we send it off to a second independent neuropsychologist. And we also give that doctor the raw data from the neuropsych testing. And we ask the second independent neuropsychologist, doctor, please review this report, the findings, the conclusions, and please look at the data to support it. And write us a report to let us know if it is accurate and reliable. And in the ideal world, no, we get back a second report that says, yes, I've reviewed everything. I've reviewed the data. It is reliable, and here is why. And we have an explanation. So like we did with the CPET and the neuropsych report, we have propped up the reliability of these independent testing that provides objective evidence. It makes it now so much more difficult for the insurance carrier to dispute the findings. After we get the neuropsych report, the third thing, and I'm purposely going through here in order. The order of how you obtain testing and your evidence is crucial. You have to start with the CPET, get your neuropsych second, and third, send your client to an independent medical evaluation, an IME, not with any old doctor. Send your client to an IME with a physician that has expertise in long COVID. A lot of the physicians with expertise in long COVID are coming from a background of treating ME, CFS, chronic fatigue syndrome, and they've been doing that for many years. But there are a handful of them out there across the country, and they're absolutely brilliant. They know this stuff inside out, and the insurance company has no one on the other side that is similar with training, education, and experience as the doctors we've been using. So now you have your client examined by a top long COVID physician, and that's where you send to your IME doctor all the medical evidence, medical records you've been gathering, the CPET report, the CPET validation report, the neuropsychological evaluation report, the neuropsych validation report. On top of that, the last bullet point, your IME doctor would also be getting letters and questionnaires that were completed by treating physicians, your client's treating physicians, letters that were completed by your client's spouse, your client's friends, or former co-workers of your clients who could attest to how your client was performing at work before falling ill, right? So that's a bit of the non-medical evidence side. But you get all of this together. You send it to the IME doctor. You ask the IME doctor, please review everything. Please examine our client and prepare a report for us answering. You usually want one or two questions in there, depending on the insurance policy language. But the first question always is client X, is Miss Brown, able to perform the duties of her own occupation, as the case may be, maybe you're in any occupation stage of a disability case, right? So her own or any occupation based on her training, education, experience. And we always qualify that question with on a reliable and consistent basis. Because the reality is, unless somebody's in a coma, most people can perform some work some of the time on an inconsistent basis. But that's not enough to not be disabled. So we want the doctors to answer the question from the perspective of client. Can Miss Brown work on a consistent and reliable basis. Okay, and that's how we've litigated and argued the cases in court. Judges tend to agree. We get back our IME report. Hopefully it's brilliant. The doctor endorses the CPET findings, endorses the neuropsych evaluation. The doctor discusses her own history in speaking with Miss Brown, any examination findings that are possible. But now we get this IME report, and you think we're done? Not yet, right? We have one more report we want. When we're done getting all these reports back, we then take everything and we send it off for an independent medical peer review. This is a review of everything by a physician who has expertise in long COVID. And then we get a final report back, a peer review that answers the question about whether the client can work on a consistent and reliable basis. At this point, the evidence of disability is substantial, if not just overwhelming. And that's the idea. The idea by this point in your case, when you're appealing, is you do not want to have a close call with the insurance company. You do not want to have conflicting medical opinions, because if you do, you will lose that case in court 9 out of 10 times because of the standards of review. You want to polarize the evidence in a way where the insurance company looks at all this evidence and is faced with the reality that if it doesn't approve this appeal, it will litigate a losing case, because there is no way a judge would reasonably look at the quality and quantity of your medical evidence and non-medical evidence and instead defer to an insurance company's medical review by a physician who does not have the requisite training or experience to deal with a long COVID case. All right. So we focused on the medical side of the case, but one should never neglect the non-medical evidence side of the case, right? And so here are some of the things that we get from a non-medical perspective. I mentioned earlier, personal statements from clients, friends, former co-workers. I find those to be powerful. We've won cases in court where judges have cited to former co-workers letters or declarations. You can even get affidavits. Think about it for a second. If you are going into court with an affidavit that you got for the appeal process and sent to the insurance carrier before the lawsuit, that becomes unrebutted testimony, because the insurance company too cannot depose these co-workers. So now you've got unrebutted testimony. Take advantage of it. Get everybody to jump in on this. The client's spouse, family, friends, co-workers, have them all shouting from the rooftops exactly why or how this person is disabled. What are their first-hand observations? Second, we like to have clients keep a symptom diary. 2 weeks. 2 weeks, 3 weeks, every day. What are the symptoms you are experiencing throughout the day? And rank them from 1 to 10. And what you'll find is over 2-3 weeks, you end up having a powerful piece of evidence that gives the court a snapshot, an insight into what it is like to live in this person's shoes. Pictures are worth 1,000 words. Third bullet point, we love photos and videos of clients. We had a client, a young lady, who was on a remarkable career trajectory until she had long COVID. We ended up sending with her appeal several photographs of her in her wedding gown in a wheelchair. And one of the questions we posed in that appeal to the insurance company is, do you believe she has manufactured her disability claim by going as far as putting on a wedding dress, putting on a mock wedding, and going down the aisle in a wheelchair just so she could collect a portion of her previous income by getting a disability claim approved? There's no good answer to that for the insurance company, right? And so you can use that sort of evidence to polarize your case. It's either the insurance carrier has to accept all the medical evidence we just walked through, all those reports, then all this non-medical evidence, including your client, a photo of your client who is not going to be in good shape, and they have to accept all that as true, right? Meet me over here to agree she meets the definition of disability, or you've polarized them and pushed them way out into la-la land, where they have to take unreasonable positions. What we don't want to do is to leave them in the middle, where there is a debate, where there is reasonable conflicting opinions by doctors as to whether your client has sufficiently proven she's disabled. You don't want that. Lastly, a good thing to grab is if you get some employment records or emails. Sometimes what we've seen is clients have really, if they're working somewhere for a long time, they have accolades, recognitions, they have, great job emails coming in, they get sick. Then you see a change. You see emails coming in saying you haven't met this deadline, or what's going on here at work, or maybe they even have a poor review performance at work. Don't be afraid to bring those into the foreground. Those things are helpful. All right, just really quickly, CPET. We discussed this earlier. It's tedious. We don't have the time to get into it, but what I want to point out is just briefly how we talk about CPET. Under the third bullet point, there's an excerpt from our appeal letter, right? We say the purpose of the CPET was to objectively assess her impairment. CPET testing uses objective measures. So terminology matters. How you portray this matters. Neuropsychological evaluation, right? Here's some excerpt from our appeal letters. We're talking about the findings from the neuropsychological evaluation. What we don't have here, though, is that I don't have to share with you, but it should be in our sample. We have a sample appeal letter showing how we put all of this evidence together. We would have another section where we speak about the expertise of each doctor who did the neuropsych, who did this, the person who administered the CPET. Then we'd also have another section talking about how each of these reports were independently validated by other physicians. Peer review. Let us see. Here is an excerpt from our appeal addressing the peer review report. Dr. X prepared a report after interviewing the client, reviewing her medical records, and independent reports of doctors Y and Z. There'd be more doctors typically. As one of the luminaries in the field of immunology and chronic fatigue syndrome, Dr. X's report and conclusions should not be given significant weight. So what we're doing there is we're starting to now elevate our doctors, our independent doctors that we have brought into this case. We want to elevate them and hold them out as the experts that they are.
Thanks for watching. We hope you enjoyed this clip, and if you did, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.